Hello, I'm Tusha Singh from Law Community. Today we'll be joined by advocate Rohan Batra. He is the founding partner at R&R Chambers and also an advocate on record. He practices commercial disputes before various courts and tribunals in India with specialized focus on in-house advocacy. Hello, sir. Welcome.
Hi, Disha. How are you?
Good, sir. So, how has pandemic affected your daily course of business, and in what innovative ways have you countered the challenges posed by it?
Okay, first of all, the fact that we are interacting through this medium is the first level of effect on all of us, I think. But if I talk about the professional side, I am a litigator by profession, and that's what we do, going to courts and trying to argue our matters. And because of this COVID, obviously, all the hearings are getting adjourned. So that part of the work stream has certainly been affected. And generally, I think we are sensing a bit of a slowdown at the industry level. Earlier, companies used to be quick enough to approach lawyers for their work, but now I think they're taking it a bit slow, being cost conscious, and when they really need to come to lawyers. So I think that is where we are affected. I think you also asked about how we are trying to overcome this. In terms of what work is concerned, there is no real way of pushing a client to give you work. But what we've tried to do during this spare time is read up more law, staying updated about the legal developments in our respective fields at least. And of late, we had been conducting a few webinars for everyone through the help of some of the senior advocates we've had the chance to work with. So that has been one of the most interesting aspects of our professional journeys, that we've conducted those webinars, and that would have only been possible because of this lockdown.
Very well, sir. So, what are your views about laying off of employees and salary cuts for the purpose of keeping law firms afloat during this time?
Oh, that's a sensitive matter. It's not every day that you come across with such a situation. So I think one should be open to all ideas, but whether layoff is one of them is very hard to say. At least for us, we are a small team, and fortunately, we've not been pushed to take a decision like this. But about the large firms who are operating out there, I think it's a tough call, and ultimately they have to look at who all can be kept on the boat for the boat not to sink, and who all have to be asked to jump out of the boat. So for the management, it's going to be a very tough call. I can't speak for them, and all I know, it's going to be very hard. But the idea should be to ensure that all the lawyers who are part of a legal setup or a law firm, the idea should be to hold on to them as much as possible, because they've spent uh, years, if not months, in the organization. And when the organization is going through a tough period, and it's a tough period for everyone, then in that situation, some compassion towards them would help. And it should not be just a business call. But ultimately, it's easier said than done. It's a very, very difficult call. And people who are taking these calls are right in their own perspective, their own way. And I'm actually no one to comment on this. But yeah, it's a pressing issue for everyone.
So, what are your views about the direct tax stimulus package that was announced by the government amidst the pandemic? Do you think it is a viable solution to the crippling economy?
Yes. I'm no economist. That's the first caveat. I don't practice that much of direct tax also. We do a little bit of the direct tax here. But as a layman, as someone who's slightly informed about how our economy is working, I feel it's a step in the right direction, because that means, number one, the government is recognizing that there is a need for a stimulus. And number two, by providing that stimulus, it is trying to address that need in some way, if not entirely. And any help, I think, at this juncture is good. Really, the criticism against the fiscal stimulus is whether it's good enough to assuage everyone's needs. And I think everyone has arrived at a conclusion that the scale at which this country is, even a fiscal stimulus that size, is not good enough. But it's certainly a step in the right direction. And I think um, everyone has received, the industry has received the fiscal stimulus in a positive way. Yes, and more can be expected, of course.
Right, sir. So what do you think about the mandatory referencing to ADR? Can it be a solution for lessening the burden of cases on courts?
Yes and no. ADR has a select purpose. It is primarily meant for commercial disputes, and at least that's how we've been using the mechanism for a long time. It is yet to find foray into other sectors, such as family law, or you can say not just blue collar crimes, but minor offenses, which can be where state responsibility kicks in. So at least the sphere in which arbitration operates, in some matters out of that basket, there is a possibility that mandatory ADR should be inculcated. And I think it's already happening at an institutional level, especially in the case of oil and gas industries, construction, wherever wherever the private parties are contracting with the government, there is already a set mandate to have an arbitration clause in those contracts. So that making ADR mandatory in those kind of cases, it's not something new. The challenge here is to actually stretch the ambit of mandatory ADR to other fields and test out whether that's possible. As far as private disputes are concerned, I am not sure whether a compulsion or a mandatory ADR will help, or whether at all it will be constitutionally valid. But as far as public contracts are concerned, I think that should be a way. And in fact, these days, there is a discussion of having mandatory mediation as well, and not just arbitration. So using both mechanisms together or separately, especially in the case of public procurement contracts, that can be a good option to lessen the burden of the court.
Right, sir. So do you agree with the decision given in the recent Quipo construction case, and which undermines the concept of seat in domestic arbitrations, or do you think it stands against the one court, one jurisdiction model?
See, my reading of the judgment is slightly different. We cannot in a blanket manner say that the decision does not uphold the concept of seat. The facts of that case were slightly different. And in that case, one of the parties who had later on challenged the jurisdiction, that party had never raised this issue before the tribunal. And it was only the first time that the issue was later raised. So the defense against challenge to the seat jurisdiction had to be one of waiver. And it's not entirely incorrect to say that that party never raised an objection to the tribunal's jurisdiction under Section 16. We've had cases in the past, Hardy exploration and all other cases where seat has been discussed. Those have been cases, and subject to my memory being right here, those have been cases where a party has always challenged seat, and that has always been the bone of contention. But here the party was silent about it, and as a result, when the question arose whether Delhi was the place where jurisdiction should have been there, or it should have been Calcutta, if I'm not mistaken, then in that case the courts were right in saying that, look, the party never objected to it, and therefore there is a straight waiver under Section 4. So from that perspective, it's fine. See, seat theory cannot be looked at, it has to also be looked at from the perspective of the other principles in the Act. And let's say if this decision was not taken, then the outcome can be that any person who remains mum throughout the proceedings, while being fully cognizant of the fact that this tribunal may not have jurisdiction. Once he gets the award against him, he might challenge it to set it aside. That will again, in a way, be uh, defeating the whole purpose of arbitration, much less the concept of seat theory. So I think the principles in play were of much higher importance than just seat. And therefore, I think to sustain the validity of the award in this case, perhaps the right decision was taken.
So what do you think about ADR that has been implemented in India and the evolution of it? Do you think that training is a problem, or there has to be much more growth that is yet to take place in India? What is your view about it?
So I feel that looking at my own personal experience, all of us who've had a tryst with ADR as a practice area have not done it in the most organized way. We've had the chance to work on a matter, we've learned on the job, and over time, you tend to become slightly better and slightly more experienced. But if there is an institutional framework which takes care of the small issues of educating oneself, or for that matter, creating a framework where all arbitration related knowledge can be shared, passed on, maybe a precedent system is developed, I think that system would really help us. And the more people get aware of this, become aware of this, perhaps the better it is. But an institutional framework which organizes, the entire thing which is unorganized right now, it would help. Otherwise, it would become like any other practice area where people can just practice for some years and get into it without the benefit of having any institutional framework. So I believe that some training is important, not just the training we get by working on a matter, but also training in the form of maybe some certification programs are there to skill yourself as an arbitrator, to skill yourself as a mediator. And those should be recognized qualifications so that even if you approach a client or the client approaches you, he knows that you're qualified and that qualification is recognized by the government, as opposed to any international certification that you can get. Once these protocols and standards are built in, which makes this industry a bit more organized through training and other certification, I feel that it would really help the practice area.
Right, sir. Sir, you just said that you have learned ADR practices on the job, and so would you like to share some of your experience on how you actually came to, develop yourself in this field?
For me, I mean, I cannot recall a special story, but what I do remember is that it was one of the initial matters I was doing. It was not the first matter, and I was lucky enough to be handed over the matter entirely. And I was the one who was preparing the affidavit of evidence, doing the cross examination of the witnesses, all the way till the final hearing. And before me were stalwarts, retired Supreme Court judges, who for a moment I thought maybe because of my enthusiasm or passion for the field, I thought I might be able to handle them. But I was so wrong. I was so dead wrong. All this while, I think they were being very considerate of me being someone who's very young in the profession. But the moment final hearing started, the game completely changed. I started arguing the way we've been taught in our moot courts, but perhaps in a slightly more refined way, if I can call it. And when I started off, I thought I would get the stage to myself and I would be arguing for 20 minutes without disturbance. Little did I know that the first question is going to pop right after 10 seconds. And that completely derailed my whole structure of arguments. I was scrambling for papers. I was searching for answers to the questions they were asking me. And in a way, I was all over the place. So the first day was a big disappointment. I thought I'd let myself down, I'd let the client down, and I thought God only knows what these arbitrators are thinking of me. So I had a pretty a nerve-wracking experience. It's only when the hearing went on for some time, I started becoming more and more comfortable. I was able to field their questions. And normally, when you see, that you are, let's say, in your early 20s or in your late or in your 30s, you feel that, you can answer everything, you know it all. But when it comes to the knowledge and wisdom which these arbitrators have amassed over years and years of toil and hard work, we are nothing. So it was both an embarrassing experience and a humbling experience for me. But one thing I learned, that if we put in the right kind of preparation for final hearing, for cross examination, then the even Supreme Court judges, who are normally arbitrators, they really appreciate you and they encourage you. And after being slapped around for 2 3 days, I did my homework. I went back, I studied, restudied the records, tried to frame my points. And when I came back, there was one day when, during the course of arguments, we had taken a lunch break, and the arbitrator, he happened to just walk by me, and he actually said, "You've done a good job." So that feeling was priceless. And it happened about 3 to 4 years back. But I remember this incident. It's because when someone of a great stature tells you that you've done something nice, you really hold on to that compliment very dearly. So it taught me a few lessons. Number one, be extremely prepared. Number two, don't underestimate your opponent or the arbitrators for that matter. And just a big takeaway, that if you do your hard work, if you're prepared well, then there will be people who will support you and pat you on the back along the way. So this is something I always remember. And every time I'm about to enter either a hearing or an arbitration, automatically, subconsciously, that incident starts playing in my head, because maybe I've been bashed around a lot. But there's always a learning I can just take out from that incident, just like a, a leaf from a book, and play it in my head. Oh, this is where I went wrong. So the judge may not have patience this time, so I need to come to the point quickly. So that these are some of the lessons I've learned, but it's been interesting so far.
So what do you think about online dispute resolution, and how do you think it can be effectively brought into practice among masses?
As far as arbitration is concerned, it has, to a very large extent, been operated online. Although ODR tries to make it online through the entire process, but arbitration, the way it works, has always been a bit of online and a bit of physical hearing involved. So starting from appointment of arbitrators to maybe having a procedural hearing, uh, or maybe deciding the timetable for the arbitration, those things happen online or maybe on a phone call, at least as far as some international arbitrations are concerned. It was more of a problem in domestic arbitrations, where even for the smallest motions, one had to schedule a physical hearing, where the venue cost, call lawyers from both sides, call clients, call the arbitrators, pay the sitting fee for the arbitrators. So I think in the area of domestic arbitration, where it was not so much of an online operation, ODR is going to help a lot. And especially in the environment we are in, when physical meetings are scarce, if not impossible. And those things really will help us in streamlining the procedure. So right from, let's say, getting your arbitrators appointed, you send an email, it's done. If you want to decide on the procedural timetable as to when will be your pleadings be completed, when will the evidence be completed, when are you going to set the dates for final arguments, all that can be decided through exchange of emails or on a phone call. And as far as other aspects are concerned, let's say cross-examination and final hearing, that's where I think a large part of the debate, at least in our fraternity, lies. Because both of them, especially cross-examination, and any lawyer worth their salt knows that cross-examination requires physical proximity with the witness, so that you are able to judge the expressions of the witness, find the right pulse when you have to put a question. I'm not sure how much online or ODR system can work. But on the other hand, there are cases which don't require cross examination at all. So, especially in those cases where evidence can be sifted through, filtered through documents itself, filing of evidences does not require cross examination of witnesses to testify or to prove those witness statements. In those cases, certainly ODR will help. It's not a replacement, but it's got a place in the system.
So when it comes to technology, like you mentioned that it is so much important, especially at this time, how do you think that, so how R&R Chambers is actually technologically advancing and innovative, uh, taking innovative actions towards litigation and on the practices of business that you engage in?
That's an interesting question. Okay, so what we've done, and let me tell you the backdrop of it. Where we've been working, we've seen some cases of COVID happening, and that sort of raises a fear, not just for the team, but also for the support staff who come. And therefore, the requirement of being able to work remotely really helps. Fortunately for us, when we started out in September 2019, we had some of the basic, at least, systems in place. Like your Office 365, cloud storage, all those things were already in place. And when this COVID happened, we didn't feel the disruption in work that much because all our emails were through Microsoft Outlook. Exchange was on cloud, and we didn't have any storage issues at all. Now, having realized what this disruption can do and what are the best possible measures that we can take, we've of course taken subscription and of systems like Zoom, Microsoft Teams, Google Meet, Blue Jeans. All these systems are already there in the organization now, which will help us conduct online meetings without having the inability or not having the access to any of the platforms. So those are already there. And I think nowadays lawyers are getting subscription to Adobe Pro Professional, which gives you access to page numbering without having to take prints of so many pages, plus digital signature. So we have those amenities now. Earlier, to be very frank, it was all printouts. We were wasting paper. We were not environment friendly in that sense. But at least this pandemic has taught us to be a bit more frugal and be more future looking. And that's why we've had these technological upgrades and advancements in the organization.
Definitely, sir. And actually, you showed a brighter side to the pandemic.
Yes, I think we should make the most of it. There's no point cribbing about it. There is no point saying, oh, we used to have physical meetings. Oh, we used to do it in this way. I mean, I think the time for that is gone. It's been 4 months to the lockdown and maybe more. And I don't see it ending anytime soon. So much better to embrace it and move on if you really want to continue in your line of work.
Right, sir. So, would you like to share with all the students or the lawyers who will be watching your interview the life lessons that you have acquired over this time of your journey from student to now a professional?
Okay. My journey from being a student, which takes me back to 2006, to now, which is 2020 actually. And so it's been some time now. If I look at the time span, yeah, it's been 5 years in college and nearly 10 years in the profession. And I can tell you, for anyone who has a little bit of passion for law, he will enjoy it every minute. And when I say enjoyment, it does not necessarily mean that it's all going to be up the graph, climbing higher and higher. There are going to be downs as well. But when you make the most of your downs is when you start climbing higher again. At least that's what my philosophy in life has been. Make the most of your challenges. Those are the times when you can really reinvent yourself. And when everything is going all right, nobody is going to change the system because you think that those systems are the reason why things are going right. But when everything is going wrong, that's the time really to introspect, rethink, reconsider, and see where have we gone wrong, what is there to improve. And a professional journey in the field of law will give you those many challenges. I can tell you that much, this profession is not meant for the weak hearted. It's not meant for the people who shy away from hard work. This profession will take your entire time, your entire mind space, your anything else which I've left out, even perhaps your health. But that is why it's important to understand that if you really want to make a mark in a profession like law, you have to be willing to give it all. And in fact, I remember my first discussion with my first boss. I started off my journey with the economic laws practice, and Tarun sir, he was heading the Delhi office, and he called me to his cabin, and he said, "What are your thoughts? Where do you see yourself few years down the line?" And I was quick to retort, and I think that's the kind of passion all litigators have. That sir, I want to become a senior counsel. I want to become like this guy. I want to become like this guy. This is why I joined law. He said, "Hold on, hold on, hold on. Are you prepared to give up all your late night parties? Are you prepared to give up sleep?" And I said, "Yeah, why not? It's no big a deal. I can do it. You've done it. I can do it. Why can't I do it?" And that's when I realized that I didn't understand the depth of what he said. Now, having spent about 10 years now, I feel that it's all consuming. And that's how law is designed, because it does not only it's not only physically demanding, at the same time, it's mentally draining yourself. And unless you really enjoy giving away so much of yourself to a profession, you will not be able to stick around, because it's not a matter of 10 years. 10 years is just, let's say, one fourth of anyone's legal career. People practice for 30 to 40 years easily. So it's a marathon. And when you're running a marathon, you have to train every day. You need to practice every day. You need to be willing to give yourself to the profession. And unless you're prepared for it, whether you're in law school or whether you're starting out, my only piece of advice would be, don't have any notions of quick success. You will get there, but don't have notions that I'm going to do this and be overnight successful. It's a profession which largely runs on perseverance, and it takes time for people to notice you. Nowadays, things are different because you have LinkedIn, you have all sorts of quote unquote social media advertising or networking, and that gives lawyers some platform which was not there. So things will move fast, but even then, it's a profession which requires maturity. And I've learned it the hard way as well. When you see in courts that junior counsels are, not that welcome when a senior counsel is standing on the other side. There are judges, of course, who make exception, who encourage really young lawyers to argue their cases. But at the same time, it's equally not true. Therefore, it requires a lot of patience. And I didn't have that patience, to be very honest. I had those dreams of having overnight success, being able to do it, achieve it, like all the students who are studying in all the good colleges, including yours, are there. But I'm only trying to say that, and this is my single piece of advice, please be patient. Please be willing to give your everything to the profession if you want to succeed in this profession. There are avenues outside law. Many people who pursue a 5-year course, sometime after working realize that they're not cut out for it. That's an excellent decision. It's not a bad decision to leave law to do something else when you've realized you don't want to spend your life doing it. So even those decisions are welcome, but you have to walk the path to realize it, to discover your own self, and whether this field is cut out for you. A 5-year course will give you a trailer, but when you really practice, that's when you understand what are the wise words you hear from all your seniors. I think I've rambled a lot, I guess, on this topic.
No, no, sir, absolutely not. It was really inspiring. But I have to ask that now talking with you, sir, this is very certain that you're very passionate about your profession. So what apart from that? Do you have any other interest areas, hobbies? What do you do apart from work?
Okay. um, so there are a couple of things, but the thing which I enjoy the most is actually having a good workout in the morning. And there's a reason how this hobby was developed. I've always been a person who enjoyed sports. I used to play basketball in school, in college, but once I got into the profession, I didn't get the time, or to be very honest, I didn't make time for it. And over time, I had started to put on weight. And just 3, 4 years into the profession, I had developed a severe backache. And that's when I realized that if I continue going at this rate, my health is going to take a toll. So after understanding or getting that realization, that's when I took a conscious call that I'm going to do what I love the most. I'm going to do exercising. I'm going to do my workouts in the morning, which gives me that extra confidence. And more importantly, it gives you the stamina to sustain a 12 to 14-hour workday. And so ever since I think September 2016, that's when I've started my workout regime. And people sometimes scoff that lawyers are supposed to um, not look fit. Lawyers are not supposed to have a flat stomach. They need to have that mature look, and they need to have their tummy out instead of being tucked in. And I was completely opposed to that idea. And this is not something I wanted to do to myself, to my body, because if I'm not healthy, then I'm not able to work. And all of this is actually not worth the while if your health is not on your side. So that's when I developed this hobby of working out. Many people will call it just doing for the sake of it, but I really enjoy my 1 hour workout in the morning, and I will not give it away for anything else. So I call it my hobby. And during this lockdown, I've gotten to do a lot more things, a lot more experiments in my physical hobby. So that's my one hobby which I do. The other is that I have been fond of reading books, but because of my workload, I was not able to manage that. And I'm not a person who reads a lot of fiction. I read a lot of non-fiction, and mostly those books that nobody will ever look at on the shelf. They fall under the category of self-help. And but I'm one of those few takers of those books. I really enjoy a lot. I devour those books and try to learn whatever I can, because my other hobby is skilling myself. I like to skill myself with new things, new talents, so that I become more competent. So that's another hobby of mine. And if you leave me on an island with nothing else, I'll still find something to do when it comes to working out, or doing something to skill myself. So these two things I keep doing on a daily basis, and that's how I keep my sanity.
So what are you reading right now?
Okay, do I have to really reveal that book?
So you don't have to. It was just I was interested. So I read the same kind
No,
of
no.
books. That is why.
Okay, so I've been wanting to read this book for a while, and it's an old classic as far as self-help people goes. It's called Think and Grow Rich by Napoleon Hill, and it's one of the used to be one of the best sellers back then. And that book is at the foundation of all these other books, and those are the books I like. So I'm almost done with that book, and I've almost taken 2 months to read it. because I didn't want to read it like a novel. I really wanted to extract the lessons which are given in the book and try and apply it to myself. And I've thoroughly enjoyed reading it.
So, how can an organization like law community prove beneficial to the legal fraternity according to you? And what do you expect law community to do in sense of bringing up new avenues for law students and lawyers alike?
I mean, it's a difficult question because it's first of all, you guys are operating it, so I'm sure you guys have a vision. But someone who's facing it as a user, or someone who's experiencing it from the outside, I appreciate the initiative of having these interviews, which I'm guessing is meant for law students to understand and take perspective from people who've already walked the path for about a good number of years. So that is a great takeaway, and I believe there are other institutions also and other organizations who are trying to do the same thing. So I think you guys are on the right track. So it's important to take people's experience and try and distribute it to as many people as possible, and no better way than an online reach. And there are no two ways about it. Perhaps the other additional stuff that might distinguish law community from others is having is having people from different background who also decided not to do law. Because I feel that when you're in a 5-year law course, and let's say you're surrounded by your students, your peers, who want to enter the legal fraternity, and those are the kind of people who are sure, I am going to do corporate, I am going to do IPR, I just want to do uh, let's say litigation. And with those kind of people, a person who's still not sure after 4 years of law, perhaps it was not in his option, but he had no other stream left, so he decided to do law. Who knows? Those people might feel a bit lost with so many people being so certain about what they want to do. So it's equally important for people to understand, especially students, that there are so many career options, even if you've done a 5-year law course. There are friends of mine who've migrated into the business side of things. There are friends of mine who've completely left law and joined a business organization. Because there are skills you acquire even while being a lawyer, which can help you in other ways in a business role. Some people have gone to journalism. Some people have taken up very niche areas of law like sports law, which are developing these days. Uh, Gaming law is there. So many things can happen. And India is not just one territory that people should focus on. People should have more exposure of people who are working abroad. So ask people who've done their masters, are working there for 5 years, what does it take to work in New York? What does it take to work in San Francisco? What does it take to work in Hong Kong, London, any other place where a person should go? The problem most of these days is that students, and I face this also, we have certain stereotypes that this is what I'm going to do when I get out of law college, without tasting all these things. And even in your 5-year internship, you might have had a chance to work with good seniors, good firms. But how many of us had the chance to really have it before them, the kind of options available to lawyers? We can only count them on our fingers, maybe 5, 6, 10. But if you approach people with extremely diverse backgrounds, people who are working abroad, people who left law, as we all discussed right now, that I think will get the real masala for your law community, and that you will be able to share with everyone. Because ultimately, I'm guessing your idea is to impart knowledge and experience of others amongst the legal fraternity, the students.
Right.
So what better way than, making it as diverse as possible? I mean, these are just my thoughts. I could be completely wrong here. and you guys are the best judge of it. You guys are running the show. So think about it. Uh, these interviews are helpful. Invite some written publications, periodicals, so that people have different ways of expressing themselves. Some people like to talk, some people like to write, some people like to do both. So have all these avenues open.
So this has been wonderful, and this is really insightful suggestion. I'm really grateful for that. So thank you so much for your time, and thank you so much for putting effort into answering these questions and for helping us out, lawyers out there. Uh, so stay safe, and best of luck to you, sir.